Live, where I get a chance to chat with luminaries in eDiscovery and related areas. This broadcast is sponsored by Reveal-Brainspace, the industry's leading AI eDiscovery platform. Don't forget to subscribe to watch me, George Socha, weekly with leaders in eDiscovery. Thank you for tuning in.
Welcome to eDiscovery Leaders Live, hosted by ACEDS and sponsored by Reveal. I am George Socha, Senior Vice President of Brand Awareness at Reveal. Typically, each Friday morning at 11 a.m. Eastern, I host an episode of eDiscovery Leaders Live where I get the chance to chat with luminaries in eDiscovery and related areas. Obviously, as you can tell from the date, the time, and the background, this is not typical. We are at day 4 of ILTACON in National Harbor. I am I've lost track now. I think this is number 10 for the week, something like that. But in any event, this will at some point also become a past episode. Past episodes are available on the Reveal website. Go to revealdata.com, select resources, then select eDiscovery Leaders Live. My guest for this episode today is Ann Halkett. Ann is Director, Solved eDiscovery Services at Alexander Holborn Bowden?
Bowden, yeah.
Bowden, okay, you never know. So Alexander Holborn Bowden and Lang, LLP. She joined Alexander Holborn in 2000 as a senior paralegal and has more than 20 years of experience. She became the litigation support manager in 2014, and then in 2021, the director of eDiscovery Services. So Ann advises and insists on a wide variety of litigation support systems and technologies, including evidence management, electronic discovery, and specialized databases and trial presentations. I'm going to keep going. She's dealt with all levels of courts, from small claims to the Supreme Court of Canada, and in a number of civil litigation practice areas, including municipal nuisance and negligence, fire loss, sexual assault, construction, commercial, aviation, personal injury, plaintiff and defense, foreclosures, and collections. And I'm going to keep going because in June 2015, Ann was featured in the Spotlight by the Continuing Legal Education Society of British Columbia to recognize her extensive volunteer work. Most recently, she was among a group of eDiscovery experts in Canada involved in drafting, and this was a major step forward.
Yes, it was.
Ultimately, 10 or more years in the coming.
Yes.
Of a Canadian certification and exam and study manual for the Association of Certified eDiscovery Specialists, ACEDS, the folks who are making sure this podcast actually gets to you. So, Ann, welcome.
Thank you, George. And I will let our marketing department know that people are reading the information that's on there.
That's right. It actually does matter.
It does
what
matter.
You sent to me. It doesn't I don't just look at it and throw it away. So if there's anything that should have been changed.
No, I think that's more than enough. Thank you.
I'd like to start today, in the time we have, talking about education and eDiscovery education. Getting your perspective from where you work, from the size of organization you work in, and because, unlike most of our audience, you're working in Canada with a different legal system, a different culture, a different set of practices, and a different set of priorities often. So education, need for and importance of.
Yeah. Education is near and dear to my heart. So obviously that's why I'm so involved in it in all my volunteer pursuits. And I think that this is one of those areas, and I see in terms of Canada, it feels like the Wild West for eDiscovery. So I think the US and some of my colleagues would agree with that. It's a little bit more mature in terms of what people know and what they're doing, generally speaking.
I'd put a code on that.
Which, okay, you can talk
Because
to
we
that.
have 1.3 million lawyers in the United States.
Okay.
How many of them do you think are litigation attorneys? I forget which. How many of them do you think are well versed?
Oh, I don't think I want to know if you're asking me.
We don't even know to go there, but you can tell from the question itself.
That's right. That's true.
Maybe it's not as uneven as you're thinking.
Okay. Well, that's very interesting. Well, I know in terms of like the Canadian landscape, I don't see it covered in many law schools, which is quite unfortunate. There are a few coming up that are starting to include more in the curriculum, which I think is fabulous. It's one of those areas, and I know I've said this to many people, and we were just talking, it's an area where what you do not know will hurt you. It's guaranteed to hurt you, so you really need to have an understanding of the landscape of electronic generally, and if you don't know, you should be seeking advice from those who do know, whether it be consultant or growing that within your team. And, sometimes it could be a paralegal, it could be lawyers on the team, anybody. And in terms of the education, I am so grateful that ACEDS started the certification program in Canada. I think just like you said, it's groundbreaking. It will only help the community over time. And I'm a big advocate of people pursuing that because I think that it gives you a level of knowledge and understanding that you can only grow from. So you have an introduction. You won't know everything about eDiscovery, but it will give you a solid foundation once you go through that.
Well, you were involved, as I noted above, as your marketing people made sure I was aware, but I knew anyway, and the drafting of the Canadian ACEDS exam. What was that process like?
It was very intensive. So it was essentially going through, like for the manual prior to the exam, it's going through and just looking at the language, because language has a lot to do with how you refer to things. Because if you come up and you start talking about it, it could have a completely different meaning in Canada as opposed to the States. So breaking it down by some things were similar, but we refer to it this way, or we're not as litigious, and we have cost penalties and a different method, different court system, and breaking it down in terms of that way so that when you give it to Canadians, they'll understand it. But we also have two different, systems in Canada. We have Quebec, which is the Napoleonic Code, and we have the common system, right? So bringing that together and making sure that you present it in such a manner that you cover them all off. So it was a little bit more general, but tried to cover it all at the same time.
So once you get out of the Napoleonic Code system in Quebec, and you get to the rest of the provinces, are you all in Vancouver working with the same set of rules, regulations, and the like as, say, the people in Ontario?
That's a great
or the people
question.
In Calgary or wherever?
So we were looking at, to a degree, the rules in terms of the definition of document. And so we were looking at the rules in each because they are different. The procedures can be slightly different in each province in terms of our court system. And we looked at, where does the majority of eDiscovery take place? And that's at the Supreme Court or Court of Queen's Bench level, which is kind of like the in-between if you're thinking about things.
Okay.
And so that's where the majority of, that's where it's going to come up.
In between, in terms of the process, in the U.S., we have a trial court where the actual trial takes place, assuming you get to a trial.
Yeah.
And then we'll have, in the federal court system, generally speaking, we've got the courts of appeals.
Yes.
And then the U.S. Supreme Court. State court systems are similar to that, but some of them have two levels of courts of appeals.
Yeah.
So are you talking about the appellate level, or is it something different?
This would be the Supreme Court, which would be the state. Sort of like the state, I guess. Okay. We also have federal court, but that's federal jurisdiction. And then so for the provincial court, the next level is Supreme Court of Canada, and that's the court, that's it. That's as high as you can go.
Okay. So the rules differ a bit. You had to address that.
Yes.
Do the practices differ? significantly from province to province?
Though the definition of document is slightly different from province to province. No, not definition of document. The definition of relevance is different, because when it's a little bit different, is typically we produce what's relevant. So it's not a question. Quebec's a little bit different. It's more of a questioning system.
Mm-hmm.
But for the rest of Canada, it's, the rules stipulate whether, the degree of relevancy. So then you have to look at that. So we defined it that way in terms of an overall global. It could be this or that. Ultimately, you still need to look at the rules in your jurisdiction to satisfy exactly what's going. But we didn't want to get into the weeds in each one. But you should have an idea of what's in those.
It makes it a bit of a challenging balancing act.
It
what
does.
You're trying to do is put together a nationwide certification program where people can actually get enough information for it to be useful.
Yes.
How did you all juggle that part of it?
Yeah, well, we got people from different jurisdictions, which was really helpful, and looked at things. We looked at practice directions outside of the rules, because some of those dealt with electronic evidence and how it should be listed.
And we can just pause here for our United States audience. When you say practice direction, I suspect many of them have never heard of that. What is that?
So that's an additional notice from the court on how things should be done. So you've got your rules that state like this dictates it, and then the things that they're not going to cover off. Practice directions sometimes become rules over a period of time. It depends, but it's a directive from the court saying, okay, you should do it this way.
Does each court prepare its own practice directions, or are there standardized ones?
No, each court will prepare their own, and in each province they'll have their own. So, yeah, that's a lot to think about.
How many people did you have working on all of this?
Oh gosh, I'm not sure exactly, but I think it was, and of course Mike would know that, but I think it was under 20 people for sure.
Yeah, but Mike doesn't get to be here. You do. Yeah. So that's one thing that has been a valuable addition to the educational toolbox for eDiscovery in Canada. What else is happening on the educational front?
That's a good question. I know locally we try and do things with ILTA and ACEDS for education, so seminars. There are sometimes, maybe in Ontario, they'll put things on.
Osgood Law.
Osgood Law absolutely has a program. I've taken a couple of their certifications.
They have a 5-day certification?
Yeah, they have 5-day, full day certification programs for a couple of them. Cybersecurity, privacy, eDiscovery and privacy. Yeah. But again, I'm big on education, so I'm going to take lots of courses too.
Yeah.
Yeah, so there's those. I think Ryerson has something in their program. University of Calgary is starting out with something there. So I'm not sure about the other ones. Canada.
Okay. Let's shift gears and talk more about, although we've touched a little bit on this, about the differences in the landscape, Canadian versus United States, when it comes to electronic discovery.
Well, I did say it was a bit of the Wild West.
Okay.
And
by that you mean?
That means, I might exchange protocols are rare. Well, you might suggest something. Oftentimes, the others on the receiving end don't know what they're reading, and they will just do what they've always done, which will be a word list with a table, and they number them according to how the rules set out. So the rules set out how, like guidelines and formats for listing evidence, which is essentially a Word document with a table.
Okay.
And numbering all your records 1.1, 1.2, 1.3, and so on that you're disclosing.
That might be a challenge.
Yes, it is a challenge. So people...
1.1 million?
1.1 million. I have seen people lists thousands of records that way. I'm not kidding you.
Okay.
And I just shudder in terms of how long it must have taken them and how much they must have billed to do that, which is shocking.
Yep. So perhaps some differences in the numbering practices, far less formality and structure around protocols and the use of protocols. What other differences do you see in the two landscapes?
Well, in terms of how people approach eDiscovery, I would say not everyone is aware of tools that are out there and how tools can help with efficiencies and cut down the time and presentation and it's endless. If you're working in this area, you totally get it, you understand it. But if that's new to you, which it is to some people, no understanding of that.
And really, why would you expect them to understand?
Exactly.
Because they haven't had, back to previous point, the appropriate education.
Exactly.
Yep.
And that's a good thing. I mean, in the ACEDS program, it introduces these concepts, email threading, artificial intelligence, and how it's used. So exactly what you don't know will hurt you. If you didn't know that you could use email threading to cut down the number of records to review, you would never use that.
Proportionality is a concept within eDiscovery that only relatively recently has come to prominence in the United States with our, I think it was 2016 changes to our federal rules of civil procedure, where references to proportionality were pulled in from several different rules and all consolidated in one place.
Right.
In the UK, proportionality has long been an area of great focus and emphasis. How does proportionality, where does that sit in Canada? More like the UK?
More like the UK.
US? Okay.
Definitely like the UK. I mean, that has been a principal concept for many, many years. So you can't spend whatever you want. So if the claim is worth $50,000 and the client has a terabyte of data, that's not going to happen. So you cannot spend $1 million on the claim or whatever that is. You have to find ways to make this work within the scope of that budget. So, there are ways to deal with that.
Yep.
You need to do targeted collections. You're going to have to look at the issues, and you're going to have pushback, there needs to be pushback on the other side saying, you need to define this, because ultimately it comes down to the pleadings and what's being claimed in there, and that's how you're going to deal with the discovery. So there has to be pushback on that in terms of defining exactly. And if the parties can't, then it's going to have to be the court that will come in. And that's when you make the cost arguments. Like, if we go down this route and it will cost this, and if you make it, a compelling argument would be someone on my end saying, looking at this and these costs and this is what's involved, laying it out so the court will understand it. And I guarantee they're not gonna prove that.
This would suggest to me that because you've been dealing with proportionality longer, because it's a much greater importance in the Canadian legal system than in the United States.
Yeah.
That you've got some lessons to teach us in the US about how to effectively handle the challenges raised by proportionality.
And
any thoughts?
Oh yeah. Well, it comes back to the notice of civil claim, right? And the defense. So being on the defense or plaintiff side, I mean, ultimately it's what's in those pleadings and the scope in terms of what's in there. But it's also pushback by defense or plaintiff, whoever, saying, really, we have to narrow the scope. It's like project management principles. What is the scope of this and what's in scope and what's outside of scope? And so what's in scope? So timelines, time periods, individuals. How can we narrow it down to exactly what is? It's that funnel, but you start with the funnel to begin with. Mm-hmm. You don't do the funnel after you get it all. You do the funnel before you get it, so to speak. And you do targeted collections, very, very targeted collections. So we're going in, these are the search terms, this person only, because they were the key player in this. And this is what we're going to look at, or only records dealing with this. And if you think there's more, then you need to argue about that and bring it up to court.
For that to work effectively, there has to be an almost ubiquitous and probably unwritten and unspoken understanding that it is appropriate to do a targeted search and a targeted collection, and that yes, around the edges maybe it should have been broader or less broad, but that's not really an area of attack, because that has been very much an area of attack in the United States.
Yeah, that's true. That's a good point. I mean, there can be arguments about this is relevant, we need to produce that. But again, it comes back to proportionality and how much would be required in order to produce that. And do you really need to get that? Is this enough? Mm-hmm. So a lot of it comes down to those arguments. So there's a lot that goes on. And we're not as litigious in the US, like what's reasonable within this. And I mean, there you will come across
very Canadian.
I know. We're so polite.
Yes.
But it's a civil way to do it. Of course, there is hard-fought litigation in terms of like that doesn't matter where you are. Like the parties are just they're at loggerheads.
Serious issues.
Yeah, exactly. They're at loggerheads and they're not willing to cave. Like I get that, but for the most part, it's like what's reasonable. And I think with our basis of case law, that's pretty much spelled out in terms of if you go down that road, you will not be successful. So.
And again, I'm going to refer to the UK system and ask how it is in Canada. In the US, by and large, you pay your own, each party pays its own eDiscovery expenses. There can be opportunity to, at least theoretically, recoup costs from the other side, typically after the litigation or near the end of the litigation. In the UK, generally speaking, loser pays. What's the approach in Canada?
It's pretty much the UK system.
So explain how that works.
So there can be, each party pays its own costs, but typically the winning party will get costs. And it's not the actual cost, it's on a scale. And winning party in their argument can ask for more, or there can be cost penalties. So for example, if you were you had a frivolous claim, you brought a claim and you're like, there's really nothing there and you're not proving your case, but you're still pushing this forward, the court can say, this is essentially a waste of our time and effort, and there will be a cost penalty against you because of that. Or you're unsuccessful in the litigation, there will be a cost penalty against you. So another reason why we're not as litigious, cost penalties and different degrees of cost penalties. It's very rare, but it could be like your actual costs in terms of your litigation, what you paid to your lawyer in the matter. Those are extreme, and
what
has
you paid to your service provider.
What perhaps? You pay, exactly, all those things. But those are extreme circumstances, and it has to be egregious conduct for something like that to happen.
Okay.
But it's typically a scale of costs, and I would say probably less than 20% of your actual costs.
Okay.
It's probably a lot less than that now, but that's generally speaking what it would
So
be.
it typically does not by any means cover what you paid.
No.
But at least it's a something back to the winning party. Okay. One of the things we were talking before about, and it's something you'd mentioned to me, and I did not appreciate the significance of, a challenge you see with respect to eDiscovery. You said photo metadata.
Yes.
And so let's not repeat, but return to that discussion, because I said photo metadata. Well, where's the challenge there? It's metadata that's there or it's not. So what's the issue? And you explained. So explain again.
Yeah, I'd be happy to do so. Again, going back to that, it's what you don't know will hurt you about this. So in terms of it's metadata, you have to review it, but you have to review it in context in terms of when was, this metadata produced. So in terms of, it could be investigative. So if it's investigative, it's privileged typically. So that comes into the privilege sphere of things. And did you really want to produce something? You can waive privilege and produce something, but
Right.
you may not want to do that, because if you do, and the other side knows anything about metadata and they're looking at dates and timestamps, you may have opened a Pandora's box.
Right. So as an example, I'm seriously contemplating suing the organization that becomes whoever it is that will end up being your client. And in the process, I send an investigator out. And that investigator takes photographs of it doesn't matter what.
Exactly.
Those are photographs taken in contemplation and in reasonable anticipation of litigation,
Exactly.
which would be the
Exactly.
triggering, more or less the triggering
100%.
event for us,
Exactly.
for you as well.
Yes.
And so those photographs should be the things that at least potentially can
Yes.
be withheld.
Yes. Exactly.
So it's remembering to look for that type of thing.
Yes. Yes. Looking at it through many lenses.
Mhm.
So in terms of like you might be in a rush to do things, but you have to make sure that you're considering all like relevance. Yes. So when we produce, it's like what's in support of our claim, but what's also relevant. What's relevant to the other side's case
Right.
as well. And yet we have to produce those records because they will ask for them. And the court will say, yes, you have to produce those because they're relevant to the dispute. But at the same time, then there's the privilege lens. And privilege can be looked at in many, many different ways because there's, as you know, there's different types of privilege.
Right. Yeah. What other, in the just a few minutes left, what other eDiscovery challenges do you see out there?
Well, I things that I see and I think about in terms of why education is so important is I see this when I get the records of other parties.
Yes.
You could tell that they forwarded the email and they redacted the header. And so now chain of custody is gone in terms of who received this. The records can be altered because you could cut and paste when you forward, saying then that they clearly did print to PDF. And so they're not presenting you with the entire record. That's a portion of the record because you can see the little icons for the attachments
that you don't have.
you don't have
Yes.
the most obvious things.
See attached, icon, no attachment.
That's right,
Okay.
exactly. But then there's other things like Excel spreadsheets or PowerPoints. You're only getting the slides, and you're like, well, did they have notes on there? Was there embedded items in that PowerPoint? I don't know. I can't really tell because you gave me a PDF, right? That sort of thing.
Right.
So there's that. And that comes back to the education of what you don't know will hurt you again. So that's another reason I'm so strong on that education component. And, and one of the things that I like about this area is the continual learning. And that you're building on your skill set. And likewise, anyone in this area needs to do the same.
Absolutely. Well, Ann, thank you very much. Ann Halkett as Director, Solved eDiscovery Services at Alexander Holborn in Vancouver, British Columbia. Yeah, that is right.
That is correct,
Okay.
yes.
I mean, I did just see you there. So. I am George Socha. This has been eDiscovery Leaders Live, hosted by ACEDS and sponsored by Reveal. Thank you all very much. And Ann, thank you.
Thank you,
much.
George. It's been lovely.